Hello, everyone. Welcome back to my session. Today, we will talk about one of the most contested and also consequential arena in AI landscape, which is copyright protection in China and US. As AI models become more and more capable in generating articles, image, and also videos, it raises a very urgent question as to who actually owns those outputs. Is it user themselves or the algorithm or the algorithm's creator or the artist whose work actually trained those models and developed those models? So before we answer these harsh questions, we now first need to gain some basic understanding about copyright. So what is copyright? Before I provide the definition, I first want to go over several misconceptions around it. You may often hear people saying that, "That's my joke. You stole my idea. It's copyright infringement." Is it correct? No, this is a misunderstanding, a very popular misunderstanding about copyright. Actually, copyright does not protect idea. It only protects unique expression of the idea. We will circle back to this point later, but here I want you to keep in mind that copyright does not protect idea. It only protects the expression of idea. Another big misconception is that you can't use historical data because it is copyrighted. This is also a misunderstanding of copyright. Actually, copyright does not protect facts or data. It only protects the unique representation and arrangement of data. So the raw and unorganized facts or data will not be considered copyrightable. This is very straightforward, right? We can't imagine anyone in this world will be able to claim authorship for the fact that water boils at 100 Celsius degree. This is scientific fact. No one should own it. No one should occupy it. We should allow everyone to access the facts and access the data for the common good. Besides, the statement that I found a great recipe, but I can't share it because it is copyrighted is also a misconception. Recipe is considered general knowledge or common sense, and general knowledge or common sense cannot be protected by copyright law. Okay, copyright law only protects the expression of knowledge rather than knowledge itself. Okay, someone might ask, what about Coca-Cola? What about the formula of Coca-Cola? Is it copyrightable? And my answer is also no. Okay, Coca-Cola's formula is considered confidential business information, which can be protected through confidentiality agreement, but not through the copyright law. Okay. Now let's have a quick overview of what copyright is not. First of all, copyright does not protect idea. It only protects the expression of idea. Secondly, copyright does not protect invention, such as software, computer program, mobile applications, which are the subject matter of patent law. So patent law protects invention, while copyright law protects the expression of idea. And thirdly, copyright does not protect brand, such as brand identity, brand name, and brand visuals, which are the subject matter of trademark law. Okay. And fourthly, copying thing is not necessarily copyright infringement. Copyright infringement only covers a small fraction of copy action. You have to be copying in a specific way of a specific target and also to a specific level to amount to copyright infringement. And finally, copyright does not require registration, and it even doesn't require publication for protection. So if you have written an article, then that article, once upon completion, will be considered copyrighted. You don't need to publish it. You don't need to register it with authorities, and you don't need to write any materials, any applications, and not only need to issue any files to authorities. Okay, the copyright will be naturally granted to all copyrightable content. Okay, without any prior requirements. Okay. However, prior registration will enhance the legal power of copyright, and it will also expedite the legal process if you finally need to enter this kind of procedure. Okay, so even though it does not require registration, but registration is a great add up. is a great addition to copyright protection. Copyright protect original expression that is a product of authorship. So here I highlight the 3 keywords: original, expression, and originality, which are corresponding to 3 key elements underlying copyright protection. So in the following section, I will go over this element one by one, from originality to expression and finally to authorship, to elaborate how these elements mean and how these elements are protected. Okay, so now let's come to the first doctrine, expression doctrine. So we have been talking about the difference between expression and idea, and I have already emphasized several times that copyright only protect expression of idea. But I guess many of you are still wondering, are still not uncertain, what is expression and how can we differentiate between expression and idea? Now I'm going to provide you several examples, okay, to illuminate their difference. First of all, here is a news article about Iran. Okay, Iran says 14-hour battle with separatists leave 28 dead in 2 cities. Okay, so here is an existing news article, and there comes a journalist who saw this news article and tried to rephrase it into his own report. And this new report, the second report, is titled Iranian Military Battle with Separatists for 17 Hours Resulting in 28 Fatality Across 2 Cities. Is it considered a copyright infringement? The answer is no, because the journalist only copied the facts and data from the first article while changing its narration. And narration is expression, while facts and data are not expression. Okay, and we know that copyright only protects expression and it does not protect facts and data. So in this case, it is not considered copyright infringement. Here is a second example. This is a picture of BOC Tower in Hong Kong. And then there is an illustrator saw this picture and was impressed by the BOC Tower. He then drew a replication like this. Is it a copyright infringement? Compare these 2 pictures. One is a realistic photo and the other is an illustration of BOC Tower from a different angle. And in this case, it is not considered copyright infringement because the physical existence of BOC Tower, such as its height, its design, its structure, its landscape, is not expression, but the drawing of BOC Tower is expression. And as we have said, the illustrator have totally changed the style, the drawing pattern, and also the angle, the perspective of the drawing. So his or her action does not constitute copyright infringement. So here I want to reiterate that copyright does not protect idea, but only the expression of ideas. The second doctrine is related to originality. The originality doctrine requires that only original expressions are eligible for copyright protection. So the authors have to prove that their work are original. They need to prove their work are different from previous work by other authors. And here is an example. We have seen all kinds of memes over internet, and some of them are adapted from existing photos. For example, a user might add a pair of eyebrows to this cute cat, and some might be adding some question mark to celebrity photos. So who will be the owners? Who will be the authors of these memes? Okay, are the celebrity, the cat, or the user who are adding these additional marks to the photos consider the author of the memes? So here is a real case that can offer some answer to our previous question. There is an organization holding the copyright to a series of Shiba memes. Okay, this is the Shiba memes. Okay, and then they found out a user on WeChat are using their Shiba memes without proper attribution. So they sue the account holder for copyright infringement. And guess what? The court established that if the memes are processed in terms of lines, contour, expression, and overall image reflecting originality of the author, then they should also be protected by copyright law. In particular, originally designed memes are copyrightable, while the memes that reuse existing picture are not copyrightable. In other words, if the memes is created and reusing some existing photo, then the memes will not be granted with copyright protection. However, if the memes are created originality, which is not, I think all the case are not originally created. However, if you have your own hand drawing and turn it into the memes, then those memes will be considered copyrightable. Or if you take a photo of your own Shiba, which is not posted by any other users, then you still will be granted with copyright of that meme. And finally, authorship doctrine. As we say, copyright is the right of author. So who is the author is a very critical question for attributing the legal power among the stakeholder. And this is also a very controversial question facing the rising AI models. So many people are wondering, are AI models considered authors? Can they be granted the copyright protection? According to existing legal framework, most countries so far only accept human authors. In other words, the work of expression must have a human claimant of authorship. Particularly in Hong Kong, the legal document rule that the works produced by a computer or with assistance of one can be afforded copyright protection, and the copyright is only owned by the person, the human, who enable generation or creation of the work. So once again, the copyright content need to have a human claimer, need to have a human author. In other words, AI models will never be considered authors under this legal framework. And the second element is causality. The expression must be causally connected to human agent. In other words, the authors need to prove that the work is created by them and the work will not be existing without their impacts, without their actions. Now I'm going to show you a very interesting case about authorship doctrine. There was a guy whose name is David, and David is a nature photographer. David put the camera on automatic focus in a forest, and then he himself was hiding behind without a chance to press the shutter. So guess what? There comes a macaque. A macaque accidentally triggered the shutter and take a selfie of itself. Here is the selfie photo of this monkey. And then David tried to claim the authorship as well as copyright protection for this selfie photo. And then now let's try to recap our memory about the authorship doctrine. It requires for two elements. The first is human, and the second is causality. So the court ruled that the copyright can only be held by human creator, by human author. So macaque itself cannot be considered as the authors. So yeah, this is the first case. And what about David? Because David's action do not have a causal relationship with the photos because it set the camera on automatic zoom and automatic focus. So his own action is not the reason for the creation of such a photo. So David do not own the authorship of the photo. So because this photo do not have any authors, so it was not protected by copyright law, and thus it was entering the public domain, and anyone in the public domain can freely use it and reuse it for their own purpose. Okay, so David and the selfie. Here is another case more relevant to AI use. Actually, it is the world's first AI copyright lawsuit, and it happened in China. The case involves two persons. One is Mr. Li and the other is Miss Liu. So first of all, Mr. Li utilized stable diffusion to create a picture and post it on Redbook. Later, Miss Liu saw it and incorporate this AI-generated picture into her own article without proper attribution. She even removes Mr. Li's user ID and watermark. So is it a copyright infringement? And the Beijing court ruled that, okay, first of all, AI-generated works are copyrightable as long as they meet the originality and authorship criteria. And as for this particular case, the court ruled that Mr. Li has designed the style by trying out different prompts in his conversation with AI models. In other words, even though the picture is generated by AI, but it also is a direct outcome of Mr. Li's conversation of AI and can directly reflect Mr. Li's aesthetic choice and his personal judgment. Okay, in other words, Mr. Li's action have a direct and causal impact over the generated picture. So Mr. Li can claim the authorship as well as the copyright protection for the photo. So the settlement is that Ms. Liu is required to remove the infringing content, make public apologies, and also compensate Mr. Li with a very small amount of compensation, okay, 500 RMB. However, if a similar case happening in US context, the result might be very different. Now let's have a look at another example happening in US and involving an illustrator whose name is Kashtanova. Kashtanova used Midjourney, an AI model, to generate a series of comic illustrations like this one, and then she compiled this image into a book titled Zara of the Dawn. Kashtanova tried to apply for the comic's copyright protection without disclosing her AI use. So then the Copyright Office, after some while, realized the image was not generated by Kashtanova, but by Midjourney. So then the office invoked the copyright protection of the image because they argue that the picture was not directly generated by Kashtanova, and also this picture is not predictable by Kashtanova. Even though Kashtanova have tried out different prompts and also tried to impose her interest, her preference over Midjourney models, but at the end of the day, the resulting picture is never predicted and is never directly created by Kashtanova. So then they argue that Kashtanova should not be granted with copyright protection of the image. However, in the meanwhile, they also argue that the same comic illustrations are composed of different copyrightable content, not only including the image, but also including the text, the storyline, the layout, and also the arrangement of the pictures. As we know, Kashtanova have made a very important decision as to what picture to retain and what picture to be deleted. And she has also arranged the comic image into a book. So even though she cannot be granted with the copyright protection of the image, but she still will receive the copyright protection for the text, the storyline, the selection, and also the arrangement of the image that she has tried to make up. Okay. So we want to emphasize this country level difference. In China, AI users are very likely to be granted the copyright for the AI output. However, in the US, users are probably not be granted with the copyright protection because those model outputs are not produced by them and not predictable by them. However, there's still a chance that the user might be granted with the copyright protection for the text, selection, and arrangement of AI model output. So anyway, they still have a way to make profits from AI. So to summarize, in the US, authorities emphasize that AI-generated content must be predictable directly by human input, which led to the denial of copyright protection for Ms. Kashtanovas AI-created image. In contrast, similar cases in China are more likely to receive legal recognition and pass judicial scrutiny. Okay, so this is a very important contextual difference. And yeah, but we know that AI model is evolving at lightning speed, and the legal framework is also evolving along the technical advancement. So we have to keep an eye on it and also need to keep ourselves reminded of the potential progress in the future.